This is State of Michigan versus Richard Daniel Collins, case number 241325595. Detective Snow, raise your right hand, please. Do you solemnly swear or affirm the testimony you give will be the truth, whole truth, and nothing but the truth?
Yes, I do.
Go ahead.
Okay. On February 23rd of 2024, White Lake Township police officers responded to a disturbance via a 911 call at Dave and Amy's restaurant, which is located within the township of White Lake, Oakland, state of Michigan. Officers identified victim on scene as Paul Umler, who stated that Richard Collins and Matthew Brock started a disturbance inside the restaurant with the staff when they felt insulted by their waitress. Paul stated that his wife is the restaurant manager, Julie Ingweller, and also a staff member named Austin Mizorek asked them to leave. Paul stated that Matthew punched Austin as they were walking out of the front door. And as Paul turned around, Richard had pulled a 7-inch knife and stuck it into the side of Paul's abdomen and stated, "Do you really want some of this cold shit?" in quotes. Then stated in quotes, "You've never had your ass kicked by a Marine, have you?" end quote. Richard briefly backed away from Paul and looked towards Matthew. Paul then grabbed a hold of Richard and slammed him onto the ground. Richard and Matthew fled the scene in separate vehicles. A waitress took a photo of the vehicle plates, and the White Lake Township Police Department officers identified Richard via his vehicle. Waterford Police Department subsequently detained Richard at his residence and turned him over to the White Lake Township Police Department at that time. We are looking to seek a warrant for Richard Collins for assault with a dangerous weapon.
Thank you. Based on the testimony of the detective, I do find that a sufficient factual basis exists to support probable cause for the crime alleged in the complaint warrant, that being felonious assault. As such, I will authorize the complaint warrant at this time. And in the interim, I'll set no bond until he's arraigned.
Thank you, Your Honor.
Thank you. Anything with respect to bond at all?
We are asking, he does have a significant criminal history, including in 1991, he had an assault with great bodily harm, less than murder or strangulation. Also in 1992, he had a concealed weapons charge. 2006, he had a possession of a firearm by a felon, and also domestic violence, and then assault with intent to maim. So he does have a large and long history of violent conduct. So we would request a substantial cash bond.
All right. And when were those last convictions?
2006 is the last one with the felony firearm, the domestic violence, and assault with intent to maim.
Okay. Thank you very much.
Thank you, Your Honor.
Good day.
You too.
Morning.
Hello, Detective. How you doing?
Pretty good. How are you?
Great. Great. Who do you have this morning?
I have Sedari, Donaldson, and Dewan Benan.
Okay.
Stella, stop it. No, go.
You want to do them both together?
Yeah, it's the same charging documents, the same case, so that works.
Yeah. Okay. Hold on one second. Let me. All right, we'll call State of Michigan versus Sedari, Deshaun Donaldson, and State of Michigan versus Dewan DeMarco Benan, case number 2413249, 1 and 2. Detective Soy, raise your right hand, please. Do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
Go ahead, sir.
On 2/21/2024, deputies from the Pontiac substation on the report of a shooting. Upon arrival to the apartment, deputies observed the victim, Cornelius Jones, on the floor with multiple gunshot wounds. Cornelius was shot in the back and through his face. An autopsy was conducted. The cause of death was multiple gunshot wounds and the manner was homicide. Deputies on scene were able to identify two suspects after arriving on scene. They were identified as Dewan Benan and Sedari Donaldson. Deputies located Dewan and Sedari walking down Auburn Avenue away from Carriage Circle. Deputies initially took Dewan into custody. Sedari was armed when he was confronted by deputies. He took off running. A foot chase ensued with deputies. He was ultimately arrested by deputies, and a 9mm Taurus handgun was located where Sedari was arrested. Detectives interviewed multiple witnesses and observed camera footage from the hallway outside the apartment where this incident occurred. It was determined that Dewan got into a physical altercation with the victim, Cornelius, inside of the apartment. The altercation started over Sedari spitting into Cornelius's sink. Sedari allegedly pulled out a handgun. He pointed it at Cornelius. At some point during the altercation, an eyewitness stated that they overheard Dewan say to Sedari, blow him, prior to Sedari shooting him. Dewan and Sedari are seen on camera running from the apartment after the incident. Camera footage showed that Sedari was armed with a handgun as he was fleeing the apartment. Detectives interviewed both. Sedari confessed to shooting the gun inside of the apartment. Told detectives he was armed while he was inside of the apartment. Both were ultimately taken into custody. They're both in custody at the jail.
Ultimately, detective, they did find the weapons as well, or find the weapon.
Yeah, so after Sedari took off running from deputies, they eventually caught up with him and arrested him, and the murder weapon was located not far from where he was arrested. He also told me that was the gun that was located by deputies, the gun that he used in the shooting. Okay.
Thank you. Based on the testimony of the detective, I do find that a sufficient factual basis exists to support probable cause for the crimes alleged for the respective defendants, Sedari, Donaldson, that being count 1, homicide, murder, 2nd degree, count 2, possession of a firearm, the commission of a felony, count 3, carrying a concealed weapon, count 4, resisting and obstructing a police officer. As such, I will authorize the complaint warrant against him for those charges. And obviously in the interim, I'll set no bond until he's arraigned.
Yes, sir.
And then with respect to 2413249 Dewan DeMarco Benyon, I do find that sufficient factual basis exists to support probable cause for the crime alleged in the complaint warrant, that being solicitation, assault with intent to do great bodily harm less than murder or by strangulation. As such, I'll authorize the complaint warrant at this time. And in the interim, I'll set no bond until he's arraigned. Do you have any other ones, detective?
That's it. I'd just like to speak on bond if I can.
All right. Do you want to be on when we arraign him, or do you want to do it now?
If I could do it now,
Okay.
I guess I'm going on today. Yeah,
okay,
so
go ahead.
In regards to Sedari, obviously, his actions resulted in loss of life. He confessed to detectives that he was the one that fired the weapon inside of the apartment. Obviously, okay. I would recommend his bond be denied. As far as Dewan Benyon goes, there's an eyewitness on scene that states Dewan essentially instructed Sedari to shoot Cornelius prior to Sedari actually shooting Cornelius and ultimately murdering him. I know he's only charged at this point with a 5-year felony, but further down the line that may change. And like I said, he essentially instructed Mr. Donaldson to shoot the victim, which ultimately he did end up shooting and killing the victim. So in regards to bond, obviously, I'd like if you please take that into consideration.
All right. Great. Thank you, detective.
Thank you, sir. Have a good day.
You as well. Hello, who's on the iPhone? Oh, hello.
Detective.
I'm sorry, I couldn't hear it, detective.
Detective Pelt, Oakland County Sheriff's Office, auto theft.
Okay. So you must have Mr. Matthews.
I do, both of them.
Both of them. Okay. We'll call State of Michigan versus Kavon Matthews, case number 2413276, and State of Michigan versus Kavon Matthews 2413269. Detective Pelt, please raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
Go ahead.
All right. On 2/23/2024 at 12:42 a.m. in the township of Highland, Kavon, however you say that, Matthews, 12/15/2005, was the driver and sole occupant of a 2012 Chevrolet Silverado pulling a silver enclosed trailer. Deputies attempted to stop the vehicle for having no trailer lights. The vehicle fled from deputies and came to a stop at Highland and Boulard Road in Highland Township. Matthews fled the scene on foot into a swamp. Sheriff's Office canine and drones were called in. Matthews surrendered and was taken into custody. Auto theft detectives Auto theft detectives Kawaja and I were called in to interview Matthews. Matthews admitted to stealing the truck and trailer. The truck was stolen from Zott Jeep in White Lake Township, and the trailer was stolen from Zott Dodge in Highland Township. I spoke with the manager of both dealerships who were advised with the early morning thefts.
You indicated that he was suspended, correct?
What's that, sir?
Did you indicate that he was suspended? He had a suspended license?
I did not indicate that in what I just said.
Oh, okay. But he did. His license was suspended, correct?
As far as I know, yeah.
Okay. Thank you. Because there's obviously a charge for each of those on each of the counts.
Right.
Okay. Thank you. Based on the testimony of the detective, I do find that a sufficient factual basis exists to support probable cause for the crimes alleged in both complaints and both warrants. In 2413276, that being unlawful driving away a motor vehicle and driving on a suspended license. And with respect to 2413269, larceny $1,000 or more, but less than $20,000, fleeing and looting 4th degree and driving on a suspended license. I do find that sufficient factual basis exists for all those crimes against this defendant. As such, I will authorize the complaints and warrants for each jurisdiction. And I'll set no bond until he's arraigned.
Okay. And also,
anything with respect to bond?
What's that, sir? Sorry.
Anything with respect to bond?
Whatever you wish, sir.
All right. Thank you.
No problem. And also, I just wanted to say that Mr. Kavon is not licensed at all, which is thus the DWS charge. So
he's got no license. Okay. Sounds good.
All right.
Thank you, sir. All right. Have a good day.
You too. Bye-bye.
Bye-bye. Morning, Detective.
Good morning.
What do you have this morning?
I have a domestic violence, possession of controlled substance, and a DWS case against Tamari Patton.
Okay. We'll call State of Michigan versus Tamari Patton, case number 2413290. Detective Smith, can you raise your right hand, please? You solemnly swear or affirm the testimony you give will be the truth, whole truth, and nothing but the truth?
Yes.
Go ahead, sir.
On February 23rd, 2024, at 10:56 hours in the morning, Tamari Patton committed domestic violence, possession of a controlled substance, and driving while suspended at North Updike Road and University Drive in Auburn Hills, Michigan, Oakland County, 48326. Tamari committed the domestic violence against Sarah Lindsay, who is his child's mother, and they have dated before. Tamari was driving a Dodge Journey, and Sarah and their children were in the vehicle. Tamari and Sarah got into an argument, and Sarah started to walk away. A witness, Gina Ambrosio, saw Tamari grab Sarah by her hair and drag her back to the vehicle before forcing her into the car. Tamari then drove down the road, and Sarah again exited the vehicle to get away. Tamari stopped on the sidewalk and got out and attempted to bring Sarah back to the car again when police arrived. Tamari was arrested, and during a search of his person, a single white pill with the markings of RP and 10 325 were found on it, which drugs.com indicated was an oxycodone pill, which is a controlled substance. A MAPS report was ran on Tamari and found he did not have any prescriptions in his name for the last 2 years. Tamari's driving status through Secretary of State also shows he is currently suspended. Tamari was arrested and is currently lodged at Oakland County Jail.
Thank you. Based on the testimony of the detective, I do find that a sufficient factual basis exists to support probable cause for the crimes alleged in the complaint warrant, that being possession of a controlled substance less than 25 grams, count 2, domestic violence, and count 3, driving on a suspended license. As such, I'll authorize the complaint warrant at this time. In the interim, I'll set no bond until he's arraigned.
Okay, would you, when he does get arraigned, will that be today?
I think so. You said he's at the jail now. If they got him on the list, he should be.
Okay.
Do you want to be here for it?
Yeah, sure.
Okay. Do you want to just hang on and put yourself on mute, and you can shut your video if you want right now, and then once he gets in here and once we're able to do his arraignment, we can just put you back on.
Okay, that works. Would you guys and then when you guys have all the bond conditions, would you be able to email them over to me?
Do they normally we can try to do that if that's possible. Did you give the email to Caroline or to Michelle?
I just tried calling her. I couldn't get through, but I can call her right back if she's back there right now and I'll let her know what it is.
Okay. Yeah, she should be. Yeah. So if you can just call her and let her know what your email is, we can probably do that.
All right. Thank you.
Okay. Thanks, Detective. You can just put yourself on mute and then shut your video off.
You got it. Thank you.
Okay. Thank you. All set, Patrick?
I'm looking at it. There's one female I did not speak with. I didn't know if she was in the same pod. Emery.
Okay. I have her here, but maybe they'll bring her in later or something.
Okay. I just assumed that they were including with Donaldson.
Okay. Maybe they will. If you need to talk to her, we'll put you in a breakout room.
Yeah, that's the last one. But other than that, I'm ready on everything else.
Okay. Sir, can you tell me your name?
Sedari Donaldson.
It's the state of Michigan versus Sedari Donaldson, case number 2413249. Mr. Gagnick.
Magistrate, good morning. For the record, Patrick Gagnick. I appear on behalf of Mr. Donaldson, who's present with us from the county jail. He's already identified himself, but just so everybody's clear. Mr. Donaldson, if you could state your name again.
Sedari Donaldson.
Thank you. And I did discuss with him that we would be proceeding by video this morning. No objection to that. So the record's clear. I did speak in private with Mr. Donaldson now. I was provided a multiple page complaint, general information as it relates to Mr. Donaldson. I was able to go over all 4 individual counts. Mr. Donaldson, we had a chance to go over the 4 charges. Is that correct?
Yes.
And you understand each count, what you're charged with?
Yes.
And you understand the maximum punishment for each of the counts?
Yes.
With that said, magistrate, no need for any formal reading. Mr. Donaldson has acknowledged the record. He acknowledged to me in private that he understood what in fact he is charged with. I'd ask that any formal reading be waived. I'd ask that a not guilty plea be entered on all 4 counts. Mr. Donaldson is making a request for appointed counsel for future court dates.
Thank you. I'll enter a not guilty plea on his behalf. The matter will be set for a probable cause conference on March 7th, 2024 at 1:30 p.m. and for preliminary examination on March 14th, 2024 at 9 a.m. Sir, since you are charged with certain criminal charges, you have the right to have an attorney represent you from start to finish. And if you can't afford one would be appointed for you at public expense. I do note that there's a request for a court-appointed attorney here in the file, and I will grant you that at this time. Also, because you have felony charges against you, you have the right to have a preliminary examination held within 21 days of today's date. At that preliminary examination, it's the prosecution's burden of proof to prove by a probable cause standard that a crime was committed and that you probably committed the crime. If you're able to do so, the matter would be bound over to the circuit court where you have the following trial rights. You have the right to have a trial in this case by judge or by jury. At a trial, you are presumed innocent until proven guilty beyond a reasonable doubt. At a trial, you have the right to see, hear and confront all witnesses against you. You also have the right to call witnesses on your own behalf, and if they won't come in voluntarily, you have the right to have the court order them to come in on your behalf. Also, at a trial, you have the right to testify if you wanted to, or remain silent if you wanted to, and that silence cannot be used against you. So, sir, you understand what you're being charged with, what the maximum penalties are, and what your rights are.
Yes. Yes, Your Honor.
All right. All right. Thank you. Mr. Gagnick, with respect to bond, I'll listen to you. However, I'm more than likely going to deny bond at this time.
My request is simply for a monetary amount. If he is able to be placed into a position to at least post it, if you would consider that on his behalf. My understanding, he does reside locally. He's been at that residence now for a short amount of time, but he does have an address to be released to. As an alternative, if the court would consider a GPS tether in addition to a monetary amount, I would make that request on his behalf.
Thank you, Mr. Gagnick. I've had a chance to listen to the statements by counsel. I've also had a chance to review the police report involved in this case, and I presided over the swear-to, so I am familiar with the facts and circumstances of the case. Pursuant to MCR 6.106, subsection B, which addresses pretrial release and custody under the Constitution, it indicates the court may deny pretrial release to a defendant charged with little I, murder or treason, if the court finds that proof of the defendant's guilt is evident or the presumption great. Based on the facts and circumstances that I've heard in the allegations, I do find that the proof of defendant's guilt is evident and the presumption great at this time. So at this point in time, I'm going to deny bond. You can obviously address that bond with the next judge at your probable cause conference. Thank you, sir. You're all set. Good luck to you. You can let the deputies know you're done.
Thank you.
This is Mr. Collins.
Hello, sir.
Hello. Okay, let me see
Hello,
this.
Your Honor.
Hello, sir.
Hello.
All right. We'll call State of Michigan versus Richard Daniel Collins, case number 24132-595. Mr. Gagnick.
Good morning. Again, for the record, Patrick Gagnick. I appear on behalf of Mr. Collins with us from the jail. Mr. Collins, can you state your name?
Richard Daniel Collins.
Thank you for that, sir. No objection to proceeding by video this morning. Was able to speak to Mr. Collins in private. Did go over the felony complaint with him. Mr. Collins did indicate he understands the charge against him. No need for any formal reading. I would ask that a not guilty plea be entered. Mr. Collins indicated that he is going to be hiring his own attorney proceeding.
Right. Thank you. I will enter a not guilty plea on his behalf. The matter will be set for a probable cause conference on March 4th, 2024 at 9 a.m. and for preliminary examination on March 11th, 2024 at 9 a.m. as well. Mr. Collins, as indicated by Mr. Gagnick, you're charged with one count of felonious assault. That is a felony charge punishable up to 4 years in prison and or a $2,000 fine. Because it's a criminal charge, you have the right to have an attorney represent you from start to finish, and if you can't afford one be appointed for you at public expense. As Mr. Gagnick's indicated, you're going to be retaining your own attorney, is that right?
Yes, sir.
All right. Obviously, just have that person reach out to the court and file an appearance when you get that person, okay? You're going to have them do that before the probable cause conference on March 4th, okay?
Okay, where are those conferences at, sir?
It'll be at the Clarkston District Court, which is at 52-2 District Court in Clarkston.
Okay, thank you.
All right, you're welcome. Sir, also because you're charged with a felony, you have the right to have a preliminary examination held within 21 days of today's date. At that preliminary examination, it's the prosecution's burden of proof to prove by a probable cause standard that a crime was committed and that you probably committed the crime. If you're able to do that, the matter would be bound over to the circuit court where you have the following trial rights. You have the right to have a trial in this case by judge or by jury. At a trial, you are presumed innocent until proven guilty beyond a reasonable doubt. At a trial, you have the right to see, hear, and confront all witnesses against you. You also have the right to call witnesses on your own behalf, and if they won't come in voluntarily, you have the right to have the court order them to come in on your behalf. Also, at a trial, you have the right to testify if you wanted to, or remain silent if you wanted to, and that silence cannot be used against you. So do you understand what you're being charged with, what the maximum penalties are, and what your rights are?
Yes, sir.
All right. Mr. Gagnick, with respect to bond.
Thank you. The complaining witness in this matter appears to be unknown to Mr. Collins. There's no ongoing contact with this individual, which leads to my argument. I believe that this was isolated in that sense. He is a business owner. He's owned a tattoo shop in Waterford now for almost 30 years. He also does reside in Waterford. He's owned his own home for 20 years. Clearly, he does have ties to the community. Admittedly, he does have a prior criminal history. My understanding, though, speaking with him, that it does date back almost 2 decades now. I don't believe that he presents himself as a flight risk. I think if presented with court dates, that he otherwise would comply with any orders. As far as a monetary amount would go, I would ask you to consider a personal bond. I believe that it's warranted. I think any other conditions would be more appropriate, again, than a monetary amount. If the court's not inclined to do that, I would ask for something on the lower end of the monetary spectrum. Thank you.
Thank you, Mr. Gagg. I've had a chance to listen to statements by counsel, as well as review the pretrial services report and recommendation, as well as the police report involved in this case. I also presided over the swear to, so I am familiar with the allegations. I do note that the defendant's criminal history does date back to the 1990s. And at least according to this, he hasn't been in any trouble since 2006, it looks like. Although the court is concerned of the fact that he does have violent convictions in his past, and then now this is yet another charge alleging some violence. So the court is concerned about the safety of the public. I do realize that he does live locally, and he has contacts with the jurisdiction here. While I don't find that a personal bond is appropriate, I will give him a cash bond with a 10% provision. As such, I will set a bond in the amount of $7,500 cash surety or 10% with the following conditions. So that you're not to have any direct or indirect contact with the complaining witness, that being Paul Umlor. All right. You're not to return to Dave and Amy's. Don't go back there.
Okay.
You're not to assault, beat, molest, or in any way verbally harass, intimidate, or threaten the complainant or any witnesses. You will personally appear for any court proceeding. You will not leave the state of Michigan without the permission of the court. Immediately notify the court in writing of any change of address or telephone number. You'll not possess any firearm or other dangerous weapon. You shall refrain from using any alcohol, any form of THC, marijuana, illegal drugs, or abuse medication. You will submit to a PBT and/or urinalysis at the request of pretrial services. You must contact pretrial services within 24 hours of your release. Commit no new criminal offenses or activity. Alcohol and drug testing 3 times a month. All right. You're all set, sir. You can let the deputies know you're done.
Okay.
Thank you, Richard. They're going to release you.
710%, Your Honor?
750.
Yeah,
Yes, sir.
7,500, 10%.
Thank you very much, Your Honor.
Have a good
All
day
right.
now.
Good luck to you.
Yeah, you too. Thank you too, sir.
Your Honor, I have a quick question.
Okay, go ahead.
I just talked with my other detective. Apparently the bond conditions get entered into Oak Video, so I can just grab them from there. And I don't have anything to add for the arraignment, so.
Oh, okay. You're all set then.
Thank you, Your Honor.
Thanks so much. Take care.
You too.
Sir, can you tell me your name?
Kavon Matthews.
This is the state of Michigan versus Kavon Matthews, case numbers 2413269 and 2413276. Mr. Gagnick.
Good morning again. For the record, Patrick Gagnick. I appear on behalf of Mr. Matthews. Mr. Matthews, if we could state your name.
Kavon Matthews.
Thank you for that. Thank you for that. No objection to proceeding by video this morning. I did speak to Mr. Matthews earlier today, understanding that there's 2 separate essentially two separate case numbers in two separate jurisdictions. I did go over both complaints with him. Does the court want to break this down into each case, or do you want to handle both together?
We can handle them both together for the most part, but they are in different files, so I will have to give them two separate bonds.
Understood. But with that said, as far as my involvement, and again, my statements would clearly apply to both cases. I did read to him essentially verbatim both complaints, that being the first one out of the 52-1 district court, the second case being out of the 52-2. But in any event, he did acknowledge that he understands all of the charges against him, the maximum punishments, as well as his rights as it relates to both cases, asking that any formal reading be waived, not guilty pleas be entered, and he is making a request for appointed counsel in both separate matters.
Thank you. I'll enter not guilty pleas on his behalf for both files. The matters will be set in the respective separate courts. The probable cause conferences are set both on March 4th, 2024 at 9 a.m. and for preliminary examination on March 11th, 2024 at 9 a.m. They'll have to work out those different dates since they can't be set on the same date because they're in different courts, obviously. So unless they're one in the morning and one in the afternoon and they're by Zoom. So they'll have to worry about that down the road.
Excuse me.
Mr. Matthews, hold on. I'll give you a chance to talk, but let me get through some of this stuff first, okay?
Yes, sir.
All right. Mr. Matthews, you heard what Mr. Gagnon indicated to you. You understand, or you've been read what your charges are, what the maximum penalties are, and what your constitutional rights are?
I understand majority of them.
Oh, the majority of them? Okay, listen, if you don't, then I'm going to go over them with you anyway. So you're charged in 2413269 with larceny over $1,000 or more, but less than $20,000. That's a felony charge punishable up to 5 years in prison and or a $10,000 fine or 3 times the value of the property stolen, whichever is greater. You're also charged with count 2, fleeing and eluding 4th degree. That is a felony charge punishable up to 2 years in prison and or a $500 fine. You're also charged in count 3 with driving on a suspended license or a license that you never had. That's a misdemeanor charge punishable up to 93 days in jail and or a $500 fine. In case number 2413276, you're charged with unlawfully driving away a motor vehicle. That is a felony charge punishable up to 5 years in prison. And you're also charged in count 2 with driving on a suspended license or driving without a license. Do you understand that?
Yes, sir.
All right. Because these are criminal matters, you have the right to have an attorney represent you from start to finish. And if you can't afford one would be appointed for you at public expense. I know that you're requesting a court-appointed attorney. Is that right?
Yeah, I haven't talked to my mom yet because I haven't been able to get to a phone. So I don't know if she got me a lawyer or not. So that's why I said that.
All right. We'll grant you one at this point in time. However, if you do retain an attorney, you need to have that attorney contact the court so that they can call off the other attorney, okay?
Okay, wait. So when I leave here, would they give me like all the stuff I need to contact you guys?
They'll give you some paperwork that will have the courts on it so that you'll know where to call.
Okay, thank you.
Okay, all right, you're welcome. So also, because you're charged with felony charges, you have the right to have a preliminary examination held within 21 days of today's date. That's a hearing where the prosecutor has to prove by a probable cause standard that a crime was committed, that you probably committed the crime. If they're able to do so, the matter would be bound over to the circuit court where you have the following trial rights. You have the right to have a trial in this case by judge or by jury. At a trial, you are presumed innocent until proven guilty beyond a reasonable doubt. At a trial, you have the right to see, hear, and confront all witnesses against you. You also have the right to call witnesses on your own behalf, and if they won't come in voluntarily, you have the right to have the court order them to come in on your behalf. Also, at a trial, you have the right to testify if you wanted to, or remain silent if you wanted to, and that silence cannot be used against you. So now, sir, at this point in time, do you understand what you're being charged with, what the maximum penalties are, and what your rights are?
Yes, sir.
All right, thank you. Mr. Gagnick, with respect to bond?
I would defer to the pretrial services report. The information Mr. Matthews provided to me appears to coincide with that. I think there are grounds that would allow for either the lower end of a bond or even a personal bond. He does reside, my understanding, with his mother in Detroit. No other criminal history to speak of. I'd ask the court to consider a personal bond.
Thank you. I have had a chance to review the police report involved in this case, and I also presided over the swear to, so I'm familiar with the facts and circumstances and the allegations at this time. I am also in receipt of the pretrial services report and recommendation, so I've had a chance to review that. I do note that the defendant is 18 years old, and other than this has no prior criminal history. The court is obviously concerned of the allegations on this. The defendant not even having a license and potentially taking part in this type of conduct, and then also obviously fleeing from the police. That's certainly a concern that the court has. Given those facts, while I don't find that a personal bond is appropriate, I will give the defendant a bond with a 10% provision on each one. I will set a bond in the amount of $4,000 cash surety or 10% on each file.
So with the 10%, how much?
So you need $800 to post, sir. Okay.
Yes, sir.
With respect to the conditions are, sir, that you're not to have any direct or indirect contact with Thad Zott at all. That's on both files. You're not to return to, sir, please don't interrupt me, okay? I'll let you finish. I'll let you talk at the end, okay? Just hold on one second. All right. So you have no contact with Thad Zott. You not return to Zott Jeep dealership on M59 or the other Zott dealership, which is at you're not to assault, beat, molest, in any way, verbally harass, intimidate, or threaten the complainant or any witnesses. You will personally appear for any court proceeding. You will not leave the state of Michigan without the permission of the court. Immediately notify the court in writing of any change of address or telephone number. You will not possess any firearm or other dangerous weapon. You shall refrain from using any alcohol, any form of THC, marijuana, illegal drugs, or abuse medication. You must contact pretrial services within 24 hours of your release. Commit no new criminal offenses. No driving without a valid license. All right, sir, what do you want me to know?
And I was asked about the person that took me. I don't know his name, but he was.
Mr. Matthews, nothing. Don't make any statements. It has nothing to do with today's date. Take it up with your lawyer.
I was talking about the dealership she was talking about. That's why I was asked where that was at, but until he said the dealership, that's why I was asking.
Oh, okay, that's all right.
That's all.
Yeah, you can talk to your attorney about that. That'll be fine. Okay. All right, anything else?
No, sir.
All right, you're all set. You can let the deputies know you're done.
Thank you. Really appreciate you.
Good luck, sir.
You as well.
You too.
Sir, can you tell me your name?
Yes, William Perkins.
This is State of Michigan versus William Henderson Perkins, case number 2400560. Mr. Gagnick.
Morning, again, for the record, Patrick Gagnick on behalf of William Perkins. Mr. Perkins, again, if you could just identify yourself.
William Perkins.
Thank you for that. No objection to proceeding by video this morning. I did speak to Mr. Perkins in private this morning. We reviewed both of the felony charges. Mr. Perkins indicated that he understood both the charges as well as the maximum punishment. As far as proceeding here, no need for any formal reading. I'd ask that be waived. Just asking that a not guilty plea be entered. He is making a request for appointed counsel for any future court dates.
Thank you. I will enter a not guilty plea on his behalf. This matter will be set for a probable cause conference on March 4th, 2024 at 9 a.m. and for preliminary examination on March 11th, 2024 at 9 a.m. Mr. Perkins, your attorney has just indicated to me that you understand what you're being charged with, what the maximum penalties are, and what your rights are. Is that correct?
Yes, I do.
Okay. And
Yes,
you
it
understand
is.
that you have the right, you understand that you have the right to have an attorney represent you from start to finish, and if you can't afford one would be appointed for you at public expense, and you're requesting
Yes,
a
sir.
court-appointed attorney at this time?
Yes, I am.
All right, we'll grant you that at this time. And as also indicated, you understand what your rights are, your
Correct.
constitutional and statutory rights?
Yes, I do.
Do you want me to go over any of them at this time?
No.
Okay, thank you. Mr. Gagnick, with respect to bond?
Perkins is 43 years old. He indicated that he does reside with his sister at the listed Wixom address, so he does have a valid release address within the jurisdiction, within the county, if he were to be released. With respect, certainly to his criminal background, as well as any other matters pending, understanding that a personal bond is not warranted, my request before this court would be the lower end of a cash bond, and I am making a request for a 10% provision.
Thank you, Mr. Gagnick. I am in receipt of a pretrial services report and recommendation. I've also had a chance to listen to statements by counsel and review the police report involved in this case, so I'm familiar with the facts and allegations. I do note that the defendant does have a significant criminal history dating back to the late 90s, which do include false pretenses, open intox, retail fraud, possession of marijuana, drunk driving, delivery, manufacture marijuana, possession of marijuana, drunk driving, possession of marijuana, double penalty, delivery marijuana, open intox, disorderly conduct, possession with intent to deliver marijuana, delivery, manufacture marijuana, domestic assault, drunk driving, third offense, felon in possession of a firearm, felony firearm, CCW, possession under 25, and he has a pending CSC charge going right now. Obviously, based on that and pursuant to 765.6A, he's not eligible for a personal bond. And the court is obviously concerned about the allegations with the amount of drugs that were found in the duffel bag as well as the home. Given those facts and circumstances, I don't necessarily find that a 10% provision is appropriate in this case at this point in time. Obviously, he can always revisit bond at the time of his probable cause conference or his examination. So at this point in time, I'm going to set a bond in the amount of $50,000 cash or surety, no 10%, with the following conditions. So that you will personally appear for any court proceeding. You will not leave the state of Michigan without the permission of the court. Immediately notify the court in writing of any change of address or telephone number. Not possess any firearm or other dangerous weapon. You shall refrain from using any alcohol, any form of THC, marijuana, illegal drugs, or abuse medication. You must contact pretrial services within 24 hours of your release and commit no new criminal offenses or activity. You're all set, sir. You can let the deputies know you're done.
Can I possibly say one thing, Your Honor?
Sure, go ahead.
Okay, I do have a next month coming up around the time of the proceeding that you have scheduled. I have a very bad eye injury. Now I have to have I believe I'm going to have a procedure, possibly a surgery on my eye, which I've already had surgery right here. But I think they want to redo it. And possibly I'm not a flight risk. I've been, during the case that I've already been going through, I've been to every proceeding on time. I haven't missed anything. And I do understand the nature of of what we're going through now. So I would just ask that you please put that into consideration as well.
When's your surgery supposed to be?
To be honest, I'm not sure. I have it on my calendar, but since I don't have that in front of me, I'm not 100% sure. I know it's next month, coming up in the month of March.
Okay.
But I had to see my specialist to the Beaumont. I deal with the Beaumont Eye Institute because I was in a very bad, I'm in danger of losing my vision.
I understand. You're going to be in front of Judge Law, I think, on March 4th. So you can address it with him and see what you can do. I mean, obviously you can ask for a tether at that point in time and maybe something lower, but at this point in time, I'm going to keep the bond the same. Okay. But you can, like I said, you can address it certainly with him in a week. Okay.
Okay.
All right. Thank you, sir.
Mm-hmm.
Good luck to you.
Thank you. Bye.
You can let the deputy know you're done.
Okay. Thank you.
Sir, can you tell me your name?
Tamari Patton.
This is the state of Michigan versus Tamari Patton, case number 2413290. Mr. Gagnick.
Good morning again. For the record, Patrick Gagnick on behalf of Mr. Patton. Mr. Patton, can you state your name again?
Tamari Patton.
Thank you for that. No objection to proceeding by video this afternoon. I did speak to Mr. Patton this morning, was able to go over the multiple counts, both that being the single felony and the 2 misdemeanors. Mr. Patton did indicate that he understands the charge against him, charges maximum punishment as well as his rights. As far as proceeding, we could waive any formal reading. Just ask that a not guilty plea be entered. Mr. Patton is making a request for appointed counsel for any future court dates, please.
All right. Thank you very much. I will enter a not guilty plea on his behalf. The matter will be set for a probable cause conference on March 4th, 2024 at 9 a.m. and for preliminary examination on March 11th, 2024 at 9 a.m. Mr. Patton, Mr. Gagnick has indicated to me that he's read to you or he's gone over with you what you're being charged with and what the maximum penalties are. Is that right?
Yes.
Do you have any questions about any of those?
No.
All right. And then he's also gone over your statutory right to a preliminary examination and then also your trial rights.
Could you say it again?
Yeah. Has he gone over your rights to a preliminary examination as well as your trial rights?
Yes.
All right. Do you have any questions about any of those?
No.
Do you want me to go over any of those again?
No.
All right. And as indicated, you understand that because you're charged with criminal matters, you have the right to have an attorney represent you from start to finish. And if you can't afford one would be appointed for you at public expense.
Yes.
All right. I'll grant you that at this time. Mr. Gagnick, with respect to bond.
I would defer to the bail recommendation report. A lot of the information contained in there that Mr. Patton did otherwise confirm the fact that he is 23 years old. There's no juvenile history to speak of. He's not under any current form of community supervision, no failing to appear for any court dates, no history of prior violence. As far as a monetary amount, with all of that said, I'm asking you to consider a personal bond. As far as any conditions would go, admittedly, Mr. Patton does reside with the complaining witness, that being Miss Lindsay. She is otherwise the mother of his minor child. I indicated to Mr. Patton that the court is the hands are tied here, that the no contact order is going to issue over our objection. But with that said, understanding that, I did indicate to him that he's going to have to find alternative residence. He indicated that he does have friends and family within the area, and he will contact the 52 3rd District Court on Monday with that address, provided that this court would allow for his release.
Thank you. I've had a chance to review or listen to the statements by counsel. I've had a chance to review the pretrial services report and recommendation. I also presided over the swear to, so I am familiar with the facts and allegations at this time. I do note that the defendant has looks like to be some pending traffic matters, both out of the 50th District Court, one for failure to display a valid license and one for driving while license not valid. And we're here again on another charge of driving on a suspended license. Given those facts, I don't necessarily find that a personal bond is appropriate. However, I will grant him a 10% provision on a lower cash bond with conditions. As such, I will set a bond in the amount of $5,000 cash surety or 10% with the following conditions, sir. That you have no contact with Sarah Lindsay. All right. I understand that's where you live right now, and that that you'd want to go back there, but at least at this point in time, no contact with Sarah Lindsay and no going back to while this case is pending.
Yes, sir.
Do you need to pick up some sort of some items, some personal items or anything?
No, sir.
No? Okay. You will not assault, beat, molest, in any way verbally harass, intimidate, or threaten the complainant or any witnesses. You will personally appear for any court proceeding. You will not leave the state of Michigan without the permission of the court. Immediately notify the court in writing of any change of address or telephone number. You'll not possess any firearm or other dangerous weapon. You shall refrain from using any alcohol, any form of THC, marijuana, illegal drugs, or abuse medication. You will submit to a PBT and/or urinalysis at the request of pretrial services. You must contact pretrial services within 24 hours of your release. Commit no new criminal offenses or activity. You must provide a valid address to the court within 48 hours. Okay? So by Monday, you got to have an address. All right?
Yes, sir.
All right. And then with respect to alcohol, drug testing, be 3 times a month
Okay.
for both. Okay?
Okay.
All right. Any questions, sir? Any questions?
No, sir.
All right. You're all set. You can let the deputies know you're done.
Okay. Thank you so much.
Thank
Good
you.
luck
You
to
have a
you.
good day.
You too. Appreciate it.
Sir, can you tell me your name?
Thomas Wolford.
This is the state of Michigan versus Thomas Wolford, case number 2413266. Mr. Gagnick.
Good afternoon. For the record, Patrick Gagnick. I'm here on behalf of Thomas Wolford. Mr. Wolford, if you could just state your name really quick.
Thomas James Wolford.
Thank you for that. No objection to proceeding by video this afternoon. Was able to make contact with Mr. Wolford this morning. Did go over the multiple counts with him, that being the 1 felony, the 2 misdemeanors. Mr. Wolford did indicate that he understood both the charges as well as the maximum punishments. Is that a true statement, Mr. Wolford?
Yes, sir.
We also went over his trial rights, understanding that he's not waiving any of those rights this afternoon. Just asked that a not guilty plea be entered. You can waive any further reading of the complaint. He is making a request for appointed counsel for future court dates, please.
Thank you. I'll enter a not guilty plea on his behalf. This matter will be set for a probable cause conference on March 4th, 2024 at 9 a.m. and for preliminary examination on March 11th, 2024 at 9 a.m. Mr. Wolford, Mr. Gagnick has indicated to me that he's gone over with you what you're being charged with. Is that correct?
Yes, sir.
And he's also gone over with you what the maximum penalties are for each one of those charges?
Yes, sir.
You understand those charges and the maximum penalties?
Yes, sir.
All right. And then he's also gone over your rights with you as far as your right to have a preliminary examination as well as your trial rights?
Yes, sir.
Do you have any questions about any of those rights?
No, sir.
All right. And you understand, sir, that you have the right to have an attorney represent you from start to finish. And if you can't afford one to be appointed for you at public expense?
Yes, sir.
And you're requesting a court-appointed attorney at this time. Is that right?
Yes, sir.
All right. Thank you. Mr. Gagnick, with respect to bond?
Thank you. Mr. Wolford's 32 years old, that he is married, 2 minor children. Currently, he does reside at the Fenton address that's listed. That would be his valid release address if the court would allow. Given the circumstances, he is employed. He does work full-time, that being for a restoration company that does cleanup work. But with all that, I'd ask you to consider a personal bond. If the court's not inclined to do that, I'm just asking for the lower end, that being of a cash bond, something that would allow him to post, get back to work, and clearly provide for his wife and children.
Thank you. I've had a chance to listen to the statements by counsel. I am in receipt of the pretrial services report and recommendation. I also had a chance to review the police report involved in this case, and I presided over the swear-to. I do note that the defendant is 32 years old, married with 2 minor children. His criminal history is pretty non-existent. He looks like he was at least charged with some sort of a ticket, traffic violation that was ultimately dismissed. And then it looks as though there may have been some sort of a juvenile contact back in 2008. But other than that, he has no prior criminal history. I am familiar with the facts and circumstances of the case. I don't find that the defendant is a flight risk. It sounds as though he was cooperative with police once they arrived. Seems as though just a bad situation all around. So given the facts and circumstances of the case, I do find that a personal bond is appropriate. I'll set a bond in the amount of $10,000 personal with the following conditions, sir. That you will not assault, beat, molest, in any way verbally harass, intimidate, or threaten the complainant or any witnesses. You will personally appear for any court proceeding. You will not leave the state of Michigan without the permission of the court. Immediately notify the court in writing of any change of address or telephone number. You'll not possess any firearm or other dangerous weapon. You shall refrain from using any alcohol, any form of THC, marijuana, illegal drugs, or abuse medication. You must submit to a PBT and/or urinalysis at the request of pretrial services. You must contact pretrial services within 24 hours of your release. Commit no new criminal offenses or activity. Alcohol and drug testing 4 times a month. Mr. Gagnon, it's my understanding that the defendant and the victim in this case work together. Is that right?
I don't have that information, unfortunately.
All right. Okay. I didn't hear and I didn't see anything in the pretrial services report and recommendation that there should be a no contact order with that individual. But what I would say, sir, is don't have any contact with him about this case, okay? You don't need to talk to him about the case anymore at this point in time, okay?
Okay.
All right, you understand?
Yes, sir.
All right. Any questions at all?
No, sir.
All right. All right, you're all set then, sir. Take care. Good luck to you.
Thank you.
Good luck to you, Thomas.
Thank you.
Sir, can you tell me your name?
Dewan Benan.
State of Michigan versus Dewan Benan, case number 2413249. Mr. Gagnick.
Thank you. For the record, Patrick Gagnick, I'm here as counsel on behalf of the jail. I'm here on behalf of Mr. Benan, who is with us by video. Mr. Benan, if you could state your name again, please.
Dewan DeMarco Benan.
Thank you for that. No objection to proceeding by video this afternoon. Did make contact with Mr. Benan this morning. I did go over that being the single felony count. I did read that to him verbatim, as well as the maximum punishment. Mr. Benan, do you acknowledge, do you understand what you're charged with?
I do, but I don't.
If you want, the magistrate can read it to you again. It's not going to change the charge, but I read to you. You understand what the charge is and what the maximum punishment is.
I understand what the charges is.
Okay. Do you need any further explanation as it relates only to the charge, not the facts, but the charge?
Yes.
What do you need clarification?
You said stranglement, something like that.
If I may, magistrate, if you want to just read the charge to him, just so everybody's clear. Again, it's the same charge that I read to him, but given the seriousness, clearly he has that right. As far as that reading would go, well, obviously I'm not going to waive it, but just asking that a not guilty plea be entered But I would defer to the court, please.
Not guilty.
Thank you. I'll enter a not guilty plea on his behalf. The matter will be set for a probable cause conference on March 7th, 2024 at 1:30 p.m. and for preliminary examination on March 14th, 2024 at 9 a.m. Sir, at this time, you are charged with one count of solicitation to assault with intent to do great bodily harm less than murder or by strangulation. That is a felony charge punishable up to 5 years in prison and or a $5,000 fine. Do you understand that?
Okay, I understand.
So it's an either or essentially is what it comes down to on that.
Okay, so
Okay.
when do we talk about it? Because
You'll be talking to an attorney. You'll be talking to the attorney about that at a later date once the attorney gets appointed for you. Okay.
Okay.
All right. So because this is a felony charge and because it's a criminal charge, you have the right to have an attorney represent you from start to finish. And if you can't afford one would be appointed for you at public expense. You're requesting a court-appointed attorney at this time. Is that right?
Yes.
All right. We'll grant you that at this time. Also, because you're charged with a felony charge, you have the right to have a preliminary examination held within 21 days of today's date. At that preliminary examination, that's a hearing where the prosecutor has to prove by a probable cause standard that a crime was committed and that you probably committed the crime. If they're able to do so, the matter would be bound over to the circuit court, where you have the following trial rights. You have the right to have a trial in this case by judge or by jury. At a trial, you are presumed innocent until proven guilty beyond a reasonable doubt. At a trial, you have the right to see, hear, and confront all witnesses against you. You also have the right to call witnesses on your own behalf. And if they won't come in voluntarily, you have the right to have the court order them to come in on your behalf. Also, at a trial, you have the right to testify if you wanted to, or remain silent if you wanted to, and that silence cannot be used against you. So, sir, now do you understand what you're being charged with, what the maximum penalties are, and what your rights are?
Okay. So I gotta wait to talk to the attorney to take it to trial.
Yes, you'll ultimately end up talking to an attorney. Okay,
Yeah, that's exactly what I want to do.
but you understand what I just asked you, whether you understand what you're being charged with, what the maximum penalties are, and what your rights are.
Yes.
All right, perfect. Mr. Gagnick, with respect to bond.
Mr. Benyon's 22 years old. My understanding that he does have two minor children, age 2 and 3. To his benefit, my understanding there's no active warrants. I did look him up in the Oakland County jail database. There's no other Oakland County warrants to speak of, no other warrants in any other jurisdictions. My understanding, again, that there's no other open matters, no probation. There's no documented history, that being of him failing to appear. Given the seriousness of the charge, and again, I was able to read the bail recommendation to him with the understanding that there's not a recommendation that he be released on his own personal recognizance. If this court would consider, I'm asking for a reasonable bond in light of the circumstances. Again, highlighting the fact that he does have an address locally, that he does not otherwise have a failure to appear for court hearings in the past.
Thank you, Mr. Gagnick. I've had a chance to listen to the statements by counsel, as well as review the pretrial services report and recommendation. I also presided over the swear-to in this case, so I'm familiar with the allegations, and I have had a chance to review the police report and the allegations in the police report as well. I do note that the defendant has just a limited contacts with the criminal justice system. However, given the facts and allegations in the case, the court is concerned about the safety of the public in this charge. Given the facts and circumstances and the fact that the court does find that the defendant or the public is at risk, I will follow the pretrial services report and recommendation in this matter. And I will set a bond in the amount of $75,000 cash or surety, no 10%, with the following conditions. First, sir, that you have no contact with the co-defendant, Sedari Donaldson, and that you will not assault, beat, molest, or in any way verbally harass, intimidate, or threaten the complainant or any witnesses. You will personally appear for any court proceeding. You will not leave the state of Michigan without the permission of the court. Immediately notify the court in writing of any change of address or telephone number. You'll not possess any firearm or other dangerous weapon. You shall refrain from using any alcohol, any form of THC, marijuana, illegal drugs, or abuse medication. You must contact pretrial services within 24 hours of your release. Commit no new criminal offenses or activity. And you're not to return to.
So you said my bond was set at $7,500.
$75,000 cash surety, no 10%. You're not to go back to the location of where the incident occurred in Pontiac, and I don't have that address handy, but I will make it part of his bond that he can't go back to the address where the incident occurred. So I don't want you to say anything, sir, at this time, but just know that you can't go back there at all. Okay?
Yes, sir.
You're all set. Good luck to you, sir.
Good luck, Mr.
You
Benan.
can let the deputies know you're done. Sir, can you tell me your name?
Malik Robinson.
Thank you. This is the state of Michigan versus Malik Zalante Shadid Robinson, case number 2413271. Mr. Gagnick.
Thank you. For the record, Patrick Gagnick on behalf of the defendant. Mr. Shadid Robinson's already identified himself for the record. I did speak with him in private this morning. No objection to proceeding by video here this afternoon, but I did speak with him in private, was able to go over that being the single felony account against him, the felonious assault, that being with the maximum punishment of 4 years. Mr. Shadid Robinson, you understand the charge and the maximum punishment against you, is that correct?
Yes.
So with that said, I'd ask the court to waive any further reading, ask that a not guilty plea be entered. He is making a request for appointed counsel for any future court dates, please.
Thank you. I will enter a not guilty plea on his behalf. The matter will be set for a probable cause conference on March 7th, 2024 at 1:30 p.m. and for preliminary examination on March 14th, 2024 at 9 a.m. Sir, Mr. Gagnick has indicated to me that you were explained what you're being charged with and what the maximum penalties are. Is that right?
Yes.
All right. Any questions about those, the charges, or what the maximum penalty is? Just what they are, sir. I can't get into what or why they were charged, but I can only tell you what they are and what the maximum penalty is. You understand that?
Yes, I understand.
Okay. And then Mr. Gagnick also went over your statutory and constitutional rights to a preliminary examination and a trial.
Yes.
Do you have any questions about any of those rights?
No. No.
No? Okay. Do you want me to go over any of those rights with you?
Please.
Sure. Since you're charged with a felony, you have the right. Well, first of all, you have the right to have an attorney represent you from start to finish. And if you can't afford one would be appointed for you at public expense. I will grant you a court-appointed attorney at this time. Also, because you're charged with a felony, you have the right to have a preliminary examination held within 21 days of today's date. At that preliminary examination or a hearing, it's the prosecution's burden of proof to prove by a probable cause standard that a crime was committed and that you probably committed the crime. If they're able to do so, the matter would be bound over to the circuit court in Pontiac, where you have the following trial rights. You have the right to have a trial in this case by judge or by jury. At a trial, you are presumed innocent until proven guilty beyond a reasonable doubt. At a trial, you have the right to see, hear, and confront all witnesses against you. You also have the right to call witnesses on your own behalf. And if they won't come in voluntarily, you have the right to have the court order them to come in on your behalf. Also, at a trial, you have the right to testify if you wanted to, or remain silent if you wanted to, and that silence cannot be used against you. So now, sir, do you understand what you're being charged with, what the maximum penalties are, and what your rights are?
I understand, yes.
All right, thank you, sir. Mr. Gagnick, with respect to bond.
Client's 21 years old, did review the jail records. It appears there's no other holds no other warrants in either Oakland County or any other jurisdictions. He indicated that he had since finished high school. His plans are to start welding school sometime here in the near future. The address listed for him, that is a valid release address. My understanding, I believe he lives there with his mother and perhaps maybe his grandmother, but he does have a stable residence within the jurisdiction. If you'd consider a personal bond, I'd make that request. If not, I would just suggest something on the lower end of monetary amount. Thank you.
Thank you. I've had a chance to listen to statements by counsel. I am in receipt of the pretrial services report and recommendation. I do note that the defendant has had a couple of contacts with the criminal justice system over the years, but nothing in recent years. I do note, I did preside over the swear to in this case, so I am familiar with the allegations. I do also note, and I did note that the defendant came in crutches. It was my understanding that he was at somewhat shot in the leg as well. So given the facts and circumstances of the case and the allegations, I am concerned about the public safety, so I don't find that a personal bond is appropriate. However, I do find that a 10% provision with a lower cash bond is appropriate. As such, I'll set a bond in the amount of $5,000 cash surety or 10% with the following conditions. Sir, that you have no contact with Dewan Harris. All right, no contact means no contact. All right. If she's anywhere or if he's anywhere, you can't be there. All right. You'll not assault, beat, molest in any way, verbally harass, intimidate, or threaten the complainant or any witnesses. You will personally appear for any court proceeding. You will not leave the state of Michigan without the permission of the court. Immediately notify the court in writing of any change of address or telephone number. You'll not possess any firearm or other dangerous weapon. You shall refrain from using any alcohol, any form of THC, marijuana, illegal drugs, or abuse medication. You must contact pretrial services within 24 hours of your release. Commit no new criminal offenses or activity. And sir, any of the contact, no contact with Dewan Harris. No contact means no contact at all. In-person contact, telephone contact, texting, emailing, social media through a third party, nothing. Okay, do you understand that?
Yes.
All right. Any questions, sir?
Yes. So I'm not granted a personal bond?
No, I gave you a $5,000 cash surety or 10% bond. That's a $500 bond you have to post.
Okay, so I just post $500 and I'm fine?
And then you'd be out. That's correct.
Okay.
Okay? You can let the deputies know you're done. Good luck to you, sir.
Thank you, Judge.
We're all set on Ms. Emery.
Okay. This is the state of Michigan versus Nikita Monique Emery, case number 240000834. Mr. Gagnick.
Good afternoon again. For the record, Patrick Gagnick on behalf of Ms. Emery. Ms. Emery, can you state your name, please?
Nikita Emery.
Thank you for that. No objection to proceeding by video this afternoon. I was able to speak to Ms. Emery just now. I did read to her verbatim that the warrant, that being the 2 felony counts, as well as the maximum punishment. Ms. Emery, do you have any questions about the charges or the maximum punishment?
No.
She has indicated that she understands the charge. No need for any formal reading, but asks that that be waived and the not guilty plea be entered. She is making a request for appointed counsel for future court dates, please.
Thank you. I'll enter a not guilty plea on her behalf. This matter will be set for a probable cause conference on March 4th, 2024 at 9 a.m. and for preliminary examination on March 11th, 2024 at 9 a.m. Ms. Emery, Mr. Gagnick has explained to you what you're being charged with and what the maximum penalties are. Is that right?
Yes.
Do you have any questions about any of those?
No.
He's also explained to you what your statutory and constitutional rights are to a preliminary examination and to a trial.
Yes.
Any questions about those?
No.
You want me to go over any of them with you?
No.
Okay. You understand that since you're charged with a crime, you have the right to have an attorney represent you from start to finish. If you can't afford
Yeah.
one would be appointed for you at public expense, correct?
Yes.
And you're requesting one at this time, is that right?
Yes.
All right, I'll grant you that at this time. Mr. Gadnick, with respect to bond?
Ms. Emery currently is serving a 65-day sentence out of Oakland Circuit from Judge McMillan. The conviction there was for robbery or something similar. The jail does indicate an out date of May 19th of this year. Ms. Emery indicated that she's currently in the process of wrapping up the cognitive behavior program. That will act to shave almost 2 months off her sentence. Her updated out date is going to be in the ballpark of May 5th. As it relates to any other open matters in Oakland County, at least, she indicated that any traffic matters out of the 52-3rd have been addressed, as well as Pontiac as well. So I don't believe there's anything else that would hold her in custody beyond, obviously, the Judge McMillan sentence. The offense date in this case dates back to May 25th of last year. I find it interesting across the board that these warrants are not being authorized until much later, and to her really downfall, the fact that she's been incarcerated this entire time, the fact now that this case has only been authorized roughly a month ago, that being January 17th of this year. Given the offense date, really, if it would have been authorized back then, she could have addressed this altogether. So just given the fairness of this, I don't think that she necessarily should be held, respective certainly of the seriousness of the charge. But essentially what's going to happen, it's just going to reset her guidelines that may very well allow her to be released and then just end up being reincarcerated. Any event, I know personal bond is probably not appropriate. I'd make that request, given the fact that she's otherwise eligible for release in 2 weeks. The court's not inclined to do that. I would just ask for something that would at least put her an opportunity to at least have the possibility of being released from incarceration in March.
Did you say that you feel that if with her finishing or completing of the CBT program that her out date will be in March, or it's still in May?
No, the listed March date right now would be May, and I'm guessing that factors in the immediate credit for good time with the 365-day sentence. The March 5th date then would factor in the CBP.
So you think she should be out in next week or the following week?
Ms. Emery, you have a release date in March once you complete the program?
Yes.
Okay.
March 5th.
All right. Thank you. I am I've had a chance to listen to statements by counsel. I'm also in receipt of the pretrial services report and recommendation. I do note the defendant does have an extensive criminal history dating back to 2003. A lot of it, the majority of it looks to be traffic as well as theft, some drugs, and then the most recent, as indicated, was an unarmed robbery that looks like she pled to back in August of 2023. She was given 365 days in jail with 20 days credit and 5 years probation. As counsel's indicated, has a release date potentially in March if she completes the program that she's in at the jail. At this point in time, she's going to be in court here on March 4th for the probable cause conference. And I would say that a bond should be set or should be addressed at that point in time as well. I don't think necessarily a personal bond is appropriate given her circumstances as it is, but she won't be getting any credit if she got a personal bond either. So
that's okay.
Given the facts and circumstances of the case, I do note, as Mr. Gagnick has pointed out, that the incident date in this was back in May of 2023. The warrant wasn't written until January of 2024, and it wasn't signed by a magistrate until February 13th of 2024. So I do note that this matter, had the either the toxicology report been back or had it been sworn to sooner, potentially she could have gotten this matter taken care of a little bit sooner. So given all that, I will set a bond, given the circumstances. As indicated, I don't believe that a personal bond is appropriate, but I will set a bond in the amount of $5,000 cash surety or 10% with the following conditions. And that you will personally appear for any court proceeding. You will not leave the state of Michigan without the permission of the court. Immediately notify the court in writing of any change of address or telephone number. You will not possess any firearm or other dangerous weapon. You shall refrain from using any alcohol, any form of THC, marijuana, illegal drugs, or abuse medication. You must contact pretrial services within 24 hours of your release. Commit no new criminal offenses or activity. You will submit to a PBT and/or urinalysis at the request of pretrial services. Alcohol and drug testing 2 times a week. All right. But you can obviously address that with the next judge on March 4th if you know something more, or obviously I think that's a reasonable bond at this point in time. Okay. You're all set, ma'am. You can let the deputies know you're done.
How much was that bond?
5,000 cash surety or 10%.
10% of
$500.
Okay.
$500.
Okay. I'm done.
Ms. Emery,
to you, ma'am.
Suggested if you have an outdate of the 5th, take it up with the court when you appear on May 4th. They may consider reducing that to a personal bond.
Okay.
You're going to be on probation at that time, right? 5 years?
Yes, 5 years.
Okay.
Okay.
So take it up with your
Have them address it
counsel.
at that point.
Yep, you're all set for today, though.
Okay.
Best of luck to you, Ms. Emery.
All right.
Thank you.
Completely
Good luck
fair.
to
Thank you for that. I was just handed a file out of West Bloomfield. I'm going to go there right now and then come back to you.
Do you want me to, why don't we put you in a break room? I think he might have
that's
some
fine.
issues. So why don't we do that? That might be faster.
Perfect.
Actually, you know what? Why don't you go ahead and do it? Go ahead and do it. I'll do this.
Try that. Okay. All right. If that doesn't work, I'll come back to you.
Okay, great.
Good afternoon, Your Honor.
Good afternoon. Can you hear me okay?
Can you hear me?
Yep, I can. You have we do the swear to on Mr. Al Najjar?
Yes, sir.
Or pardon me, Al. He's Mr. Nader. I'm sorry.
Yes, sir.
Okay. So we'll call State of Michigan versus Jason Ramsey Nader, case number 2413298. Detective, oops, I'm sorry, Cameron. Detective Muchler, can you raise your right hand, please? You solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Go ahead, sir.
On February 23rd, officers Peruzzi, Kassab, and Miller were dispatched to 4031 Fox Point for a mental health call. Officers met with Deborah L. Najjar, her nephew Jason Nader, and Deborah's mother Julia Najjar. Jason told officers that he had asked to use Julia's car, and when she stated no, he became agitated and started yelling. Julia then went to her bedroom and shut her door when Jason came to the door and started banging on it. Both Julia and Deborah stated Jason is off of his medication and is bipolar and suffers from borderline personality disorder. Deborah explained the officers were also out to their residence on Wednesday, February 21st for a welfare check. Deborah stated Jason had been violent but told officers that nothing had happened due to not wanting him to get arrested. While telling Officer Miller this, Officer Miller observed bruising on Deborah's right side of her jaw. When asked if it was from Jason, she stated it was from Wednesday. Deborah could not remember if she was punched or choked, but knew it happened Wednesday because her face had swollen up. Officers ultimately arrested Jason for domestic violence. Jason's criminal history consists of an assault and battery charge in 2019, domestic violence, and or knowingly assaulting a pregnant individual, second offense in 2020, along with another assault and battery in 2020. This case was sent to the Oakland County Prosecutor's Office, and a 1-count felony domestic violence third offense warrant was issued for Jason.
Thank you. Based on the testimony of the detective, I do find that a sufficient factual basis exists to support probable cause for the crime alleged in the complaint warrant, that being domestic violence, third offense notice. As such, I'll authorize the complaint warrant at this time. In the interim, I'll set no bond until he's arraigned.
Thank you, Your Honor.
Do you have him right there, or?
Yep. Yeah, we sure do.
I'm gonna come to you.
Yeah, why don't you?
You guys all set? Thanks.
All right, Mr. Nader, can you hear me okay?
Yes, Your Honor.
Okay. I'm going to have you speak to Mr. Gagnick. He's going to be your attorney for this morning. This afternoon. He's going to help you through your arraignment, okay?
Okay.
All right, I'm going to put you in a breakout room with him.
Hello, can you hear us okay?
Yep, we can hear you. Detective or officer?
Yes.
Is there a way you can close the door so he can be there with his attorney without you inside?
Yep, I only stay here to make sure that the audio is working fine, and then I leave.
Great. Okay.
Rob, we're all set on Mr. Nader.
Okay. All right, this is the State of Michigan versus Jason Nader, case number 2413298. Mr. Gagnick.
Good afternoon. For the record, Patrick Gagnick, up here on behalf of Jason Nader. He is present with us from the West Bloomfield lockup. Mr. Nader, could state your name, please?
Jason Nader.
Thank you for that. No objection to proceeding by video this afternoon. I did make contact in private with Mr. Nader just now. Did review the felony complaint with him as well as the maximum punishment. Mr. Nader indicated that he understood the charge and the punishment as well. Mr. Nader, is that a true statement?
Yes, sir.
Thank you. No need for any formal reading. I would ask that that be waived and not guilty plea be entered. Mr. Nader is going to hire his own private counsel for any future court dates.
Thank you. I will enter a not guilty plea on his behalf. The matter will be set for a probable cause conference on March 4th, 2024 at 9 a.m. and for probable cause, for preliminary examination on March 11th, 2024 at 9 a.m. Mr. Nader, Mr. Gagnick has indicated to you that he's explained to you what you're being charged with and what the maximum penalty is. Is that right?
Yes, Your Honor.
He also indicated to you that you have the right to have an attorney represent you from start to finish. And if you can't afford one to be appointed for you at public expense.
Yes, Your Honor.
And you told him that you're going to retain your own attorney. Is that right?
Yes, sir.
All right. He also explained to you what your statutory and constitutional rights are to a preliminary examination as well as a trial.
Yes, sir.
Do you have any questions about any of those rights?
No, sir.
You want me to go over any of those rights with you?
No, sir.
All right. Thank you. Mr. Gagnick, with respect to bond.
Thank you. The complaining witness in the matter, my understanding was Mr. Nader's aunt. He was residing with her, that being at the Fox Point address. He does acknowledge, he does understand that a no contact order will follow. He indicated that he would be able to find alternative residence with family in West Bloomfield. I've advised them to follow up with the court on Monday with that address, just so that the court is apprised of that. My understanding is gainfully employed, that he does work as a mortgage lender. He's been doing that now for a number of years. I don't have the benefit of his criminal history other than my conversation with him. I don't believe that he's on probation or parole. There may be a number of criminal contacts. I believe it's been at least over a year since the last contact. Given that the court is probably not inclined to issue a personal bond, I would still make that request. If the court's not inclined to do that, I think the conditions are more appropriate than the monetary amount, given the fact that he is going to retain counsel. Clearly, he's demonstrated a willingness to address the matter. I would just ask for the lower end of a cash bond with the 10% provision if you feel that's appropriate.
Thank you. Detective or officers, anything from the police department?
I'll leave that up to the discretion of the court, Your Honor.
Thank you. I've had a chance to listen to the statements by counsel. I've also had a chance to review the police report involved in this case. And also I have presided over the swear-to, so I'm familiar with the facts and allegations. I do note that the defendant does have a criminal history that does include some assaultive crimes, obviously with the crime that we're here today being a domestic violence third offense notice. He obviously has prior domestic violence charges. He also has an operating while visibly impaired in 2013, an assault and battery out of 2019, another domestic violence second in 2020, an assault and battery, another assault and battery in 2020, and then another matter that had been dismissed in March of last year. Obviously, the court is concerned about the safety of the public when defendant is not on his medication. Obviously, the defendant needs to remember to take his medication. He needs to do that some way, shape, or form, whether he needs to have a phone remind him, somebody else remind him, keep track on a notepad, whatever he has to do, sir. You have to take your meds, obviously. All right, those are your prescribed meds, and you need that. All right, because we don't want you to keep ending up where you're at. Understand?
Yes, Your Honor.
All right, thank you. So while I don't find that a personal bond is appropriate, I will give him a cash bond with a 10% provision. As such, I'll set a bond in the amount of $10,000 cash surety or 10% with the following conditions. Sir, that you will have no contact for a period of time now while this case is pending with your aunt, Deborah Allen Najjar. Okay, no contact means no contact. No in-person contact, no telephone contact, no texting, no email, no social media, no through a third party. Do you understand that?
Yes, sir.
All right. And you're not to return to 4031 Fox Point Drive in West Bloomfield, Michigan. Do you have items there that you need to get? Some personal items, clothes, anything else?
Yes, my glasses.
All right. All right. I'll allow you to go there one time with a police escort to obtain some of your belongings. All right. You will not assault, beat, molest, in any way verbally harass, intimidate, or threaten the complainant or any witnesses. You will personally appear for any court proceeding. You will not leave the state of Michigan without the permission of the court. Immediately notify the court in writing of any change of address or telephone number. You'll not possess any firearm or other dangerous weapon. You shall refrain from using any alcohol, any form of THC, marijuana, illegal drugs, or abuse medication. You must submit to a PBT and or urinalysis at the request of pretrial services. You must contact pretrial services within 24 hours of your release. Commit no new criminal offenses or activity. Alcohol and drug testing 4 times a month. All right. Continue to take all prescribed medication. Seek or continue any mental health counseling or treatment within 48 hours. Provide valid address to the 48th District Court or pretrial services. All right. Do you understand that, sir?
Yes, Your Honor.
All right. Good luck to you.
Thank you.
Thank you, Your Honor.
You're all set.
Set.
I think so, Patrick.
All right, I'm gonna head in the courtroom. Thanks, sir.